Hi there, folks. This is Professor Hector Agostini from Middlesex Community College, and I'm putting together a small video for my law students, and this would be course LGL 102, Section 1 of Business Law. Now, we've had a bit of a problem with this situation we have in the country, and I've been trying to see if about getting some sort of videos to you guys so we can get back on track and finish the course for some of you. I know some of you will need grades, so I will try to have some sort of grading system consistent with the letter grades that many of you have asked for. Anyway, let's go on to page 222 of the textbook we had. We finished up with the beginnings of contracts, and again, what I want to do is pretty much start up where we left off, which was basically page 222. Now, we talked about contracts, and contracts, of course, you have a offeror, an offeree. You have consideration underlying the contract itself. And I want to refer you back to page 202. And on page 202, they talk about the relationship between the offeror and the offeree, the acceptance of the offer, and the underlying consideration, which you'll find on page 203. Now, the consideration, of course, is that thing of value that is being exchanged between two people. I sell you a car for $1,000. You're getting consideration of the car, which has a value. I get the $1,000 from you. That's the consideration I'm receiving, which is $1,000. Now, going back to page 222, we talk about third-party rights. When someone owes you money, you have a piece of property. You owe me $1,000 for the car I sold you. That's a piece of property. You have to give me the $1,000. Well, yes, you do. That $1,000 has a value. I can give it to someone else or assign it to someone else. And if you go to page 223, they talk about the assigner and the assignee. When I assign my $1,000 to someone, that means I'm turning it over to that person. You still have an obligation to give me the $1,000. But now the fact you have to give me that $1,000, I've transferred to someone else called the assignee. I am the assignor. You can pronounce it assignee, assignor. But the correct way is assigner. I'm the guy that is assigning to someone, turning it over. And the assignee is the one that's going to receive it. You can also have that money given to someone else, like a third-party beneficiary, as they point out at the bottom of page 223. And this is someone who is not part of the contract, but who's going to benefit from the contract. So if I say to you, I want you to turn that money over to my brother rather than to me, my brother is the third party beneficiary of the deal, and you have to turn the money over to him. What if you don't turn it over to him? Does he have a right to sue you? Yeah, because he has privity in terms of the fact that I am instructing you to give my money to him. Now, covenants and conditions on page 224. A covenant is a requirement, as they point out on page 224. A covenant is an unconditional promise to a person, okay, to perform to a person. And basically what it means is if there's a contract between two people, you can throw in a clause, covenant, that requires something that you must do in order for the contract to be performed and be executed. Now, we also get into conditions of performance, the different types of conditions of performance. For example, condition precedent, not precedent, but precedent. I'm offering you a job, but you have to have your BA degree to get that job. Having the BA precedes you're getting the job from me. That's a condition precedent, not precedent, but precedent, okay, because it precedes the contract. I can also have a condition subsequent. Now, condition subsequent means you must perform something, you must do something after the contract is signed. For example, you come to me, get a job for me, but you must take a drug test and pass it. You take the drug test, you fail it, you're out of a job. Wait a minute, we had a deal. You gave me a job, you offered me a job. I accepted the job. Yes, but we have a condition subsequent. In other words, you must pass the drug test in order to keep that job. Now, let's get into what has to be done with respect to the contract. 225. Discharge of performance. Discharge means having done it. having executed it, so to speak. You can discharge an agreement, and basically what it boils down to is we're getting rid of the performance that has to be done. The performance, of course, is what you have to do. We can have what's called a mutual rescission, which the two of us get together and we say we're going to rescind the contract. Rescind means to basically make it void or null. We have novation. Novation means I get someone else to work in my behalf, or you get someone to do something on your behalf. We can have an accord and satisfaction. That's a little tricky because with an accord and satisfaction, what you're doing there is you're reaching an accord, an agreement, and some sort of satisfaction. It's basically sort of like an amended contract. Now, you can also discharge a contract by a person, for example, who cannot perform, and this is called discharge by impossibility of performance. Let's say you're supposed to paint my house, and you get into a very serious accident, and unfortunately you can no longer use your right arm, you're right-handed, you can't paint my house. I can try to get someone else to paint that house for me. That would be novation. But I cannot possibly paint your house now. So what happens? We discharge the requirement of performance because it's a possibility of performance. In other words, there's no way you can do it. Now what happens if we have a breach of contract? A breach by definition is when someone breaks something. Here, when you have a breach of contract, what it basically means is that someone has refused or cannot do whatever is required of him or her within the contract. And there are different types of breaches. Let's get into page 226. Complete performance means you've done what you're supposed to do. I do what I'm supposed to do. Everybody's happy, hopefully. Then we can have a substantial performance with a minor breach. Let's say, for example, you hire me to clean up your property, and I cut your grass, I do some planting, I've got the bags of the leaves and everything else I'm going to take with me, and for some reason or other I forget 2 or 3 bags. Not a big thing. I've basically done the job. You're going to send me a check to do the job, and then you call me up and you say, hey, Agostini, you didn't finish the job. You left 2 or 3 bags there. You're supposed to pick them up. It's not really worth my while to go back there. I've got a crew and I'm on the road. I'll tell you what I'll do. I'll discount it $20. Is that acceptable? Yeah, that's acceptable. We have substantial performance. A minor breach. Why? Because I'm supposed to take those leaves with me and I haven't. But now we sort of have an accord and satisfaction. In other words, I'll discount you $20. You're happy with that. You put out the leaves with a normal pickup, trash, whatever it is that you have in your neighborhood. Fine. We can also have a material breach, sometimes called inferior performance, and that's when, you don't do what you're supposed to do. Do I have to pay you? Probably not. It all depends upon, you might have to pay for some things, but very little, if anything. And a material breach, by the way, is pretty much grounds for a lawsuit. And the lawsuit would be, let's go to the next page, 227, damages. You know what damages are? And it's not when you punch somebody in the nose and break his neck or something like that. It's when you have to pay for the value of the harm you have caused someone else. Now, we've talked about damages before, but let's get into more specific ones. The first one they mention here on page 227 is compensatory damages, and that is paying the person for the value of what he or she has lost because of your actions or inactions, whatever the case may be. And they give you some very good examples there. For example, if I hire you to do a job and I don't let you finish the job, well, you've given up the possibility of doing work for someone else, possibly another job. And I say to you when you show up on the first day, hey, I changed my mind. I really don't want you anymore. But wait a minute, I gave up a job at $60,000 a year for 2 years. Yeah, but I changed my mind. So you've lost the possibility of earning money for the next 2 years. Possibly. I'm going to have to pay you because I have breached the contract. I've caused you a monetary harm. That is, you don't have a job. You're not able to earn money. Now, consequential damages are a little bit different. Consequential damages, and they give you a very good definition here on page 227. And let me just read it, it's a little easier. Foreseeable damages that arise from circumstances outside a contract. In other words, we have a contract and something pops up, something happens to you because of the contract. It's really my fault. So that would be a consequential damage. I'll have to pay for it. It may not be a lot of money, but I'll have to pay for it. Liquidated damages, that's an interesting little beast. In many causes in a contract state that there will be liquidated damages. What does that mean? If I don't do a performance of some kind, I may not lose money per se, but I will lose time or maybe a client. And in order to make me whole as a person financially, to make a person whole means you put the person back to where he or she was before the deal. With liquidated damages, basically, I'm going to give you a certain, it's almost like a penalty clause, so to speak. So if you're supposed to move in on a particular day and you have a mover and he delays by a day, and you have to stay at your old apartment for an extra 2 or 3 days, you get charged for those extra 2 or 3 days at the old apartment. Liquidated damages would mean he would have to pick it up, but you've got to get it into the contract. In other words, if you don't perform properly, I suffer monetary damages because of it. You're going to have to pay the liquidated damages, in other words, to make me whole. The extra rent, the extra apartment I have to rent out, or going to a motel or something like that, those will be liquidated damages. Again, it's sort of like a clause to force people to make sure that they maintain the contract the way they're supposed to. Now, can I take advantage of liquidated damages or something like that? You caused me a damage of some kind. Yeah, you're not supposed to. This is on page 229, what we call mitigation of damages. Mitigation of damages means you're supposed to try to lessen the amount of damages that you would hold the other person responsible for. So if the guy says to me, well, if I don't show up on time, I'll put you up in a hotel for a week. Can I take advantage of that and maybe squeeze an extra week and a half or 2 or something like that out of him? I'm not supposed to. If the damages he suffers requires me to be in a motel for a week's worth of motel, fine. Can I somehow arrange things in such a way that I get an extra 3, 4, or 5 days? I like the swimming pool, I like the restaurant, I like the room service, I like the booze in the little bar that they have there. No, I can't do that. So I have to do things that will minimize or mitigate, as they say, the damages involved. Now, how do you force people to comply with contracts? Well, we've got the courts. The courts are 2 things: courts of law, courts of equity. Courts of law means we follow the law to the letter of the law, whatever the law says you must do. But courts are also courts of equity. Equity means fairness, propriety. And one of the things that you do in a court of law, on page 229, court of law, court of equity, specific performance. These are equitable remedies. In other words, I didn't do what I was supposed to do, and I can take you to court and force you, under specific performance, to do what you're supposed to do. You're supposed to sell me your car. You changed your mind. Well, I want that car. It's an antique car, and I really want it. Good price. You changed your mind. I still want the car. Take it to the court. Court says, under the principles of equity, you must perform specific performance. What does that mean? You've got to sell me that car for the agreed upon price. Another equitable remedy, bottom of page 230, reformation. Sometimes the courts will reform the contract because it might be not quite fair to both sides, or one side or the other. And therefore, we will have reformation, and again at the bottom of 230, an equitable doctrine. Remember, equitable means fairness, that permits the courts to rewrite a contract to express the parties' true intentions. Because sometimes, 2 people get together, their intentions are not quite summarized properly in the contract, so the court will sort of interpret it and redo the contract. Again, it's the idea of bringing fairness to both sides. An injunction, pretty straightforward. The court says, you can't do this, you can't do that. It's a good way for something that might be somewhat illegal, that might force you to do something that you shouldn't do. you have an injunction to stop the execution of that particular contract. Now, arbitration of contract disputes, I've mentioned this before. If you sign a contract, make sure that you look very carefully at choice of law, which might include an arbitration clause. What does that mean? It means that if you have a beef against the other party, you don't necessarily take it to court. You might take it to what is called an arbitration board. And the arbitration board will have an arbitrator, a person who specializes in interpreting contracts and what people should do. Now, again, I'm giving you the specific page numbers. If you have problems with the specific pages, email me, because some of you may have the old edition of this textbook. Let me know and I'll tell you what the correct pages are. Now, in this chapter, I want you to do cases 10.3, 10.5. Now, I'm going to cover 2 pages in chapter 11. I don't want to cover 11, but the 2 pages that are very important to us. And those are on page 243, 244. Licensee, licensor. In your pockets, many of you have a little piece of paper or a card that says license. That is not really a license. That is a representation or a documentation that you have a license. What's a license? A license is the right to do something. If you lose your license, you get stopped by a cop. Police officer if you want. Sir, I have a license. Where is it? Well, I don't have it on me. The police officer can easily check to see if you are licensed to drive. The fact you don't have the license with you, you're supposed to have it. But they can check today with computers. The license itself is the right to do something. That piece of card in your wallet, that just says you have that right. Now, when you have a license to do something, it means you have a right to do something. Let's say, for example, I start McDonald's Corporation. And someone wants to open up a McDonald's. I can license the other person to use the McDonald's name. It's my name, McDonald's. So I will be the licensee. I'll be the licensor, and the other person will be the licensee. He will buy the right from me to use my license under my particular agreements. That would also be called a franchise. But if you look at the bottom of 243, you'll see the licensor, the person that owns the license, can designate to a licensee, transferring the power of the license to the licensee. So again, look at the licensing agreements, arrangements, and again, they go on to 44. If you ever get into a franchising agreement, licensing agreement, watch the licensing agreement that you have with a licensor. It can severely restrict you. Now, let's go to chapter 12, which is sales, contracts, leases, and warranties. I'll cover a few pages and then we'll knock off. I want you guys to email me if you've got problems. If you've got the old edition, again, let me know. And I will correspond the pages of this edition with the old edition, because I have the old edition at home. Now let's get into some sales, contracts, licensing, and warranties, and things like that. So let's go on over to page 2. Let's see, and get the right page number. That's going to be 253 at the bottom. Sale of goods. This chapter deals with sales contracts, licenses, leases, and warranties. A sale means I'm transferring property from myself to a buyer. You have a seller, buyer, okay? And on page 254, they talk about the UCC, the Uniform Commercial Code. Now, sales arrangements, sales contracts are governed by English common law. However, the common law is kind of tough at times. So a number of years ago, they came up with what is called the UCC, Uniform Commercial Code. And it's a series of rules, regulations, so to speak, to simplify sales contracts, to simplify lease contracts, transfer of property, warranties, and things like that. And I'll get into what those are in a few minutes. Now, the UCC was put together. There are different portions of it. Some of it covers sales, warranties, and things like that. Not all states subscribe to it. Some states only subscribe to portions of it. Some states subscribe to all of it. Some states do not subscribe to any of it. The idea is to facilitate transactions between one state and another. So if you're in New York State, Massachusetts, if both states have accepted a portion of the UCC, then that particular transaction would be covered by the UCC, and any disputes would be covered by that UCC regulation. Article 2 of UCC specifically covers sales, and it facilitates sales transactions between people of different states. All right. Now, what are goods? Over on page 255, you can see what a sales transaction is. Buyer, seller. It's nothing more than a contract where I transfer the right I have to a particular product, goods, service to someone else. That's called a sale. And the person, of course, is going to pay me for it. How does the person pay for it? He's going to pay usually with money. It could be a barter transaction, but usually it's money, as they point out. You have the sales contract. I offer you this, you accept. We have agreement, sale of the good is transferred over to the purchaser, the buyer, and payment is made by the buyer to the seller. It's very straightforward, although you've got to be careful how you do it. When we talk about goods, we're talking about products. We can also talk about services, and that's when you do something for someone. All right. Article 2A on page 256 of the UCC, leases. A lease is very much like a license arrangement, and if you look at the top of 257, again, it's the same thing, just different names. Lessor, the person who has a piece of property. Lessee, the person who's going to lease that particular property. The arrangement, the contract, is called the lease. It could be equipment, it could be house, it could be land, it doesn't matter what it is. But here, the lessor owns the right to a particular piece of property, leases it to the lessee, who's getting the property. And again, the property could be a house, it could be equipment. And then we have the lease payment. So if you want to buy a car, well, I can't afford a car. Teacher salary's not too good. But I want to lease the car. The car comes to me under the lease agreement. I make lease payments periodically, okay? It's almost like a purchase on a time basis, but quite different. I'm not going to get into all the terms. You can read those as well as I can. I'm not going to bore you with the details. Make sure you read them, though, because I may test you on it. Now, 258. Acceptance. You have to have acceptance like any other contract, okay? And as they mentioned there, under the firm offer rule on the left-hand side of the page, a UCC rule that says that a merchant who puts out a good for offer, so on and so on, it's got to be accepted, and it's got to be accepted under certain terms, all right? The seller can't just change things around, or the lessor can't change things around. You can read about identification of goods. I'm not going to bore you with those things. But by the way, on 259, make sure you talk about the statute of frauds. We talked about the statute of frauds. Certain transactions must be in writing. If they're over a year, they must be in writing. If it's a certain value under the UCC for sales, it's got to be in writing. Okay? There's some exceptions to this, but not too many. Now, passage of title on 260. For those of you who own a car, you know what a title is. That's that piece of paper. Well, it's the ownership. That's title. The piece of paper just says you have ownership title to this property. And when you sell your car to someone, what do you have to do? Transfer title. That's exactly what you're doing in a sales transaction. You're transferring title to your property to someone else. For that transfer of title, now the person gets a title of his own on that property, you will pay for it. Now, I'm not going to stay away from some of this other stuff. You can read it as well as I can, like FOB and stuff like that. Those are particular terms of sales contracts. Don't want to bore you with those. However, sale of goods by non-owners on page 262. Anybody ever come up to you and say, would you like this watch? I've got a lot of watches like this for you. You have to think, is that really his watch? If it's not, it may be a stolen property. If it is, stolen goods. On page 262. What happens if you buy goods from people who are not the rightful owners of this property, non-owners? You've got a problem legally. But also, that contract can be voided by you. Why? Because the person is selling you something that he has no title to. Can he sell you something he doesn't have title to? Theoretically, no. Can he practically? Yeah, here's my watch. I'll take it off, sell it to you. You give me 10, 15 bucks. I'm happy as a clam. You've got a brand new watch, undervalued. But it is a stolen property. And the rightful owner has a right to take it from you. So if you pay for it, then you got a problem. You got a problem. Fraudulently obtained goods, very similar to stolen goods, basically. You know, you get something through fraud, you cheat someone somehow, misrepresent yourself, you get the property. Can you sell it? Yes and no. Yes, in the sense that you have it. What do you say? Possession is 9/10 of the law. Well, that's a common fallacy, because if you can't prove it's yours, the rightful owner shows up and says, this is mine. He can take it from you. He can force it from you through the courts. Now, I'll skip the entrustment rule. Now, remedies for breach of sales and lease contracts. We know what a breach is, right? A breach, of course, is when someone doesn't do what he's supposed to. And we also have breach of sales contracts and lease contracts. And what do you do when you have the breach of a sales contract or a lease contract? You can force the issue. You can take it to court, and very similar to what we saw before with breaches of regular contracts, you can force performance. You can have the sales contract reformed. You can have it rescinded. Any one of a number of things. They're quite similar to what we've seen before. I'm not going to bore you with those details, but you might want to look at, in particular, on page 264, 265, some of the remedies that are available to you as a purchaser, as a seller. Now, warranties. A warranty basically is a promise. It's a guarantee that something will happen. So as we see on page 265, we talk about warranties, and it basically says that you are promising someone property that will act in a certain way, that will perform in a certain way. I take this pen, I sell it to you. What do you expect the pen to do? Well, I should be able to write with this pen. Can't write with the pen. What do I do then? Well, what I do then, of course, is I take it back to the seller and I say, this pen doesn't write, I'd like a new pen. But wait a minute. You buy the pen, that's your problem. Well, pen should write. If it doesn't write, I should get you to give me my money back or a brand new pen. Now, I'm just going to wrap up on page 266 and give you a case or two to look at. Express warranty, that's a promise you make specifically when you sell a product. This pen will write. That's an express warranty. Implied warranty, I buy the pen, the guy doesn't say anything to me. It is implied that this pen will be able to function as a writing implement. If it doesn't write, I didn't say it will write, I just said I'm selling you a pen. Yeah, but it's assumed that anybody who has a pen should have a pen that writes. That would be an implied warranty. And then implied warranty of merchantability, again, it's the same concept, that a product that is sold should be able to do what it's supposed to do. All right, I think we'll knock off with this. Let me just wrap up with implied warranty of fitness for human consumption. I buy something, I bite into a rock, a piece of shell, bone or something. It's not supposed to have that. That's implied warranty, fitness for human consumption. It should be edible without a problem. And then implied warranty for fitness of a particular purpose. This pen is supposed to write. That's the purpose of this pen. It's not to lever boxes open. It's not to cut open an envelope. If I misuse it, the warranty doesn't apply. But if I use it correctly and it doesn't operate, that's fitness for a particular purpose. Now, for additional homework, I'd like for you to look over cases 267, 12.1, and 12.2. 12.1 deals with implied warranty of merchantability. Product's supposed to do what it's supposed to do. And implied warranty of merchantability, again, quite similar but slightly different concepts. Again, this is Hector Agostini. Make sure that all of you in my class email me so I have your emails so we can decide how we're going to continue this course. Send me suggestions as to what you think I might want to include. I obviously will have to abbreviate the syllabus, but follow the syllabus for now. Thanks again, folks, and I'll be talking to you soon. Bye now.